morning, everybody. Thank you very much for coming to this session. It's rather early, and anybody who was at the Mozilla party last night, well, thank you very much for being here. So we have a panel touching on GDPR, on some databases that an organization called ICANN maintain and within our community, and then we want to talk about some broader issues about regulation affecting the internet. My name is Peake. I work for ICANN, the Internet Corporation for Assigned Names and Numbers, and if you don't know about ICANN, we administer the domain name system. We do so on a global basis. We have a community of multi-stakeholders, some of whom are here today. Multi-stakeholders meaning representatives from all different, well, stakeholder groups. So we have government, business, civil society, which includes academia and activist groups and NGOs, technical organizations and so on, globally represented, and we make policy for the global internet. And that's one of the issues we will discuss today. We do our policy in a bottom-up process, which means it's inclusive. It comes from the stakeholders that I talk about, not from people like myself who work on ICANN staff. So it's a bottom-up and inclusive global process. It's something that we're proud of, that we've developed over many years. And I hope that perhaps you would consider participating if you don't already, because the more wisdom, the more people and knowledge we have in these processes, the better they are, of course. So get involved, as particularly if you think that we're not doing it quite right, because the opportunity is really that you get involved and you help us do it right. So please think about that. The session today, we're going to talk about the domain name system and a database or databases called Whois, and the information in that database, which is about registrant data. So if you register a domain name, some of your personal information is in that database, but it's also used for important technical and cybersecurity purposes, but of course it is a lot of personal data. So how that data is used and access to it is something that we want to think about. So when we were thinking about organizing this session, and I want to give credit to Joanna, who's our moderator today, for having ideas about organizing it and actually helping us organize it and putting it on. On one level, the micro level, we were talking about how we get access to that data and what are the correct ways to access that Whois data so that it can be used in ways that it has traditionally been used for. But the other thing, and this is the main, I think, point of the session, is more of a macro level, that the internet is global by nature and by architecture, and that legislation being adopted and also being talked about a lot regionally and nationally, is going to affect how the global internet functions. It's at risk of seeing a patchwork of regulation that then organizations like ICANN and businesses and so on will have to respond to. And how we do that is particularly important. So we'd like to think about that particular sort of macro issue as much as the access to the Whois database, which is an example of that with the GDPR legislation. So with that, I'd like to quickly run through our panelists. As I mentioned, Joanna Kulesza is the moderator today and professor at the University of Lodz. She's also one of an active part of one of our stakeholder groups within ICANN, a group that represents the interests of individual internet users. We call the at-large, and as I mentioned before, when we think about this session, you probably saw on the agenda as an ICANN session. The ICANN in that sort of title is really the at-large group and Joanna's help in organizing this, so thank you very much, Joanna. My colleague, Elena Plexida, who is one of our senior directors for government engagement at ICANN. We have different engagement groups at ICANN. I focus on civil society and academia. Elena works in the government engagement group. Greer, who's responsible European public policy at Cloudflare. And Cloudflare are interesting as a cybersecurity platform provider and so on, but also they're one of our registrars, so they are people you can register domain names with. Gregory Mounier, sorry Gregory, I've probably butchered your family name again. The European Cybercrime CENTR at Europol. Walter van Holst, who is with EDRi. Peter van Roste, who's the General Manager of CENTR, which is the European CCTLD Domain Name Association. CCTLD is country code top-level domain names like .be or .fr. Cristina Monti, Policy Officer at DG Justice and Consumers with the European Commission. So that is the introduction, and I can then sit down and give a little bit of space to a quite busy panel, and good luck, and I'm looking forward to it. So thank you. Over to you, Joanna. And you have one mic, and I'll leave another here.
Thank you very much, Adam. Thank you. Thank you for setting this up. Adam said I had the idea, that's true, but it's all his work. So thank you very much for setting up the panel. I'm also very much looking forward to the discussion. We have a full panel, so without further ado, I'm going to move on to our panelists. The plan is for Elena to give us the background of what the Whois controversy, so to speak, is, even though there's no Whois, and allegedly there has never been a Whois, but that's all up to Elena to explain. Then we will move on to Caroline and Gregory, trying to identify the challenges for accessing data. Why would we need a Whois database? Why would we need access to that data? What is a legitimate interest? And what kind of data would be within that legitimate interest that individual institutions might want to access? Then we will move on to Walter, giving us the civil society perspective. Where should we set the limits for access? Who should identify them and how specific they should be? And then we will move on to Peter and Cristina, trying to identify the state perspective, so to speak, to identify the regional or national challenges in regulation, law setting, standard setting when it comes to accessing data that might be considered personal data and that is used for registering. As already said, without further ado, over to you, Elena.
Thank you, Joanna. Thank you very much. Good morning to everyone, and thank you for being here so early in the morning. I have to admit I'm pretty sleepy, so excuse me beforehand, honestly. So yes, indeed, I will touch a little bit on what is the Whois and why it is there, but also I will also try to touch a little bit on the bigger picture. What is the Whois? An analogy often used is referring to the Whois as the phone book of the internet. Nevertheless, this analogy is not accurate and tends to be misleading. So what is it actually? When a person or a company wants to register a domain name, they go to a registry or a registrar, and they have to provide their name and contact details. ICANN requires the registrars and registries, who are the so-called contracted parties, to collect this data. And these data are collected to ensure that if something goes wrong in the network, technically, you know who to contact. As of May 25th, ICANN put in place a so-called temporary specification to comply with GDPR, creating a two-tier system. So ICANN still requires the contracted party to continue collect registration data, but only a limited part of it is now publicly available, publicly displayed. Effectively, personal data are not publicly displayed anymore. The ICANN community now is working on a permanent policy for the Whois, including on whether and how and under which conditions there should be access to third parties with legitimate interests to non-public data. And as Adam mentioned, Joanna has done a very good job with putting together a panel consisting of, I would say, pretty much all the parts of the community and different interests there. So what is the Whois for? As I mentioned, the Whois is there to ensure that if something goes wrong technically in the network, you know who to contact. That has been its purpose historically. You have to imagine, back in the 60s when the internet was starting, it was a bunch of engineers, academics in a garage, and the Whois at the time was literally a piece of paper where they kept the contact information of other academics, so they could pick up the phone and tell them, hey, your part of the system has an issue. So it was literally a piece of paper. When ICANN was created with the mission to ensure the stability and security of the internet's unique identifiers, it inherited the Whois. Naturally, as this was meant as a tool to ensure stability and accountability of the system. And keep in mind that accountability or transparency, you name it as you want, is inherent to the way the internet is built. So as the internet grew, the use of the Whois grew as well. In effect, the Whois was a tool for law enforcement. They used it to track down operations of websites, take down DDoS attacks. Greg will refer more to it. It was also used by intellectual property right holders to track trademark theft, consumer protection organizations, cybersecurity investigators, all just people like me and you who will check the Whois to see if there's a dodgy website and not buy from it if it looked suspicious. So what the Whois is not, Joanna alluded to that, it is not a single database. It's a common misconception that it's a single database. It does not exist in that sense. ICANN doesn't have it, and how could it have it since it's not a database? It's a decentralized thing of many databases that the contracted parties have. It's not only the ICANN contracted parties that have databases of Whois registrations. It's also the RIRs, the regional internet registries. Here in Europe, we have RIPE, for example, and they have their own Whois. They have taken another approach. They have taken the approach that their data are all about legal entities, hence the GDPR does not apply to them. They're also the country code top-level domains who also have their own databases, and in fact, they do not fall under ICANN policies, but Peter will explain it much better about that. So in all, it's about 2,500 contracted parties who are the data controllers, together with ICANN, and all these people have to come together to make the policy. And you understand that this is not a very easy task in itself, and also taking into account that we're talking about a multi-stakeholder community that for good reasons represents all kinds of different interests, so it makes it even more complicated, but hopefully at the end it will help into having a good and all the better policy. If I may turn to the bigger picture, we are now discussing the effect of GDPR on Whois. Depending on the standpoint, someone will say, or you might hear that it was an awakening for the ICANN community so as to look into privacy issues in a better way, of course. Or you might hear that it created unintended consequences. Actually, both people consider it's both. Both of them actually happen. GDPR is just the beginning. There are other regions and other countries around the world that are considering privacy legislation for very good reasons, of course. There will be more legislation. Apart from privacy, there are other real problems on the internet, like fake news, hacks, abuse, trafficking, you name it. And all these need to be tackled. I think there are two important things to highlight here with respect to that. One is that we have to differentiate between the internet and what is on the internet. So while it's true that social media, search engines, online advertising, video streaming platforms are all accessed through a connection to the internet, they are not the internet. They are applications that are running on top of the internet. So the underlying problem is not the underlying infrastructure, if you may. Our problem is not exactly the internet. Lately, it has gained a very bad reputation. So we should take a step back and realize we should not blame it all on the internet. When we're trying to fix problems on the internet, we should ensure we do not tamper with the underlying infrastructure. And second, the internet as a tool is one by nature, by architecture. I mean, the medium is one, which means that what you do regionally will touch what you do globally. Or speaking of different aspects of policy, when you're doing something to protect human rights, it will affect the digital economy, it will affect cybersecurity. On the other hand, when you try to do something for cybersecurity, it will have an effect on human rights. It's like the real life, but the fact that the internet is one medium augments this effect. This means that it's high time for all of us to understand that we need a holistic approach which takes into consideration every aspect. We need to find better ways than we have so far. All of us, I mean the technical community, the governments, the private sector, the civil society, to work together in the internet tradition, I would say. The tradition of the internet has always been collaboration. It's a collaborative project, the internet. We call it the world's biggest peace project, if you think of it. So we should all work together better to ensure that the internet continues to grow and it does not fragment it in the future. Thank you so much.
Thank you very much, Elena. The good part about representing users is that we get to hear to all sides of the story. So I'm going to hand over to Caroline now, giving us an insight on what the operators, the registries, and the registrars think of this whole GDPR challenge that ICANN is facing. Caroline, over to you.
Thank you very much. Thank you everyone for coming this morning, this early hour. I'm Caroline Greer, Head of European Public Policy at Cloudflare. For those of you perhaps not familiar with Cloudflare, we are a web security and web acceleration company. Many different facets to our business in pursuing our mission to build a better, more secure, safer internet. In the main, so we're a cybersecurity company and a web acceleration company. We are also a domain name registrar. So this puts us in a very interesting position when it comes to the Whois debate, because we end up seeing both sides of the fence, if you like. So Whois has been a very useful tool for our cybersecurity experts internally to pursue their activities in fighting cybercrime, looking at malware, botnets, phishing, disinformation that's been apparent on the Whois has been very useful to us. Equally, as a domain name registrar, we're subject to the ICANN framework and ICANN contract. And then, of course, we have the GDPR framework, which is key. We are obviously compliant to that. As Cloudflare, we've taken the decision to apply that framework globally across all our services. So this, applicable law consideration is paramount to us. So I think, this debate has been fascinating. I do think the ICANN community at large came to this debate very late in the process. And I guess Whois is maybe, as Elena said, perhaps one unintended consequence of the GDPR. This, despite the fact that the Whois debate has been rattling on for well over a decade now, I think, and particularly European registries and registrars have consistently raised some of the issues that the Whois database presents vis-a-vis the previous European data protection framework. So that being said, we are where we are, and I think the ICANN community has really stepped forward to try and address this issue, which has been immensely complex, trying to address this issue in a very condensed amount of time. And you're looking at all sections of the ICANN community coming from different geographical areas, different perspectives, the IP community, law enforcement, registries, registrars, users, right around the globe. And of course, everybody trying to grapple with the GDPR and interpret it, and interpretations are coming out in many different ways. So the policy development process that ICANN has put together has been truly fascinating. And I dare say, I think the ICANN community might walk away from this process as a community with one of the deeper understandings of GDPR, perhaps than many other different communities as a result. So if I put on the cybersecurity hat for a second, as I said, this Whois has been one tool in the toolbox that our cybersecurity professionals internally have used, and they certainly miss it. So we no longer have this data at our disposal, which we frequently use to track phishing, malware, cyber criminals online, and sort of do mapping exercises vis-a-vis other domains that they may have registered as well and may be used for malicious effects. So I think Greg will probably speak a little bit more to the concerns of the security community in losing this personal information that is apparent on the Whois. I will say it hasn't been the end of the world for us. So we've many tools in our toolbox, and this is just one thing that we did use. So the sky has not fallen in for us personally as a cybersecurity company. Equally, we are not perhaps in the attribution business that many other larger cybersecurity companies are. We have a sort of a different business model, but it is regrettable. But it is what it is. We understand the GDPR is there, and we have to follow it. From a domain registrar perspective, so we implemented the ICANN temporary specification that appeared last year. It was done in quite a hurried fashion. I think that this temp spec appeared. Not all registrars were 100% happy with it, because it was one interpretation at that point in time that we all had to apply quite quickly. Debatable whether it really stacked up truly against the GDPR, but it was one interpretation of that. We implemented it. I would say not all registrars did, or some implemented some parts of it. So there already you were starting to see some fragmentation and different actions taken by registrars depending on their own interpretation of GDPR, whether they wanted to apply it just to the European users, whether they were applying it globally as we were. So, you know, it's probably not quite a uniform implementation of the temp spec, but it is what it is. So basically, essentially on our Whois database, if you go into the Cloudflare registrar Whois, we redact the personal data fields, the name, the email address, the address, and all that appears is a very kind of essential core technical information, name servers, that kind of thing. What we do supply and what was required by the temp spec is an email address. So if any parties claiming a legitimate interest to that data, they can email us and state their case, if you like, and we will make an assessment and release or not that data. We have received little or no requests to that effect, which may be just indicative of the fact that we are, you know, not a GoDaddy, not one of the larger registrars at the minute. May also be indicative of the fact that this process is not quite known out there to end users, so they do not know that this mechanism exists for them to contact registrars directly. So we've been able to manage that quite well. So the EPDP process, phase 1, let's say, is coming to an end fairly soon. So there will be a report issued in a number of weeks, and that will be sort of the permanent, if you like, policy that we will have to implement. So there's probably some tweaks that we'll have to make based off the temp spec. Phase 2 will be the more interesting, probably more controversial process. So the idea there is to create a unified, centralized access model for third-party requests to registries, registrars, which may or may not be controlled by ICANN. So ICANN acting as some sort of gating authority, if you like. So if you're a security professional, somebody in the IP community, claiming legitimate interest to Whois data, you can go to the centralized system, maybe be issued with a token, and then approach the registries and registrars who would release the data. So there are a lot of issues around that, you know, who really owns the data, who makes that decision about who has a legitimate interest, et cetera, et cetera. So we will be watching that very carefully as Cloudflare. I mean, for us, user privacy is absolutely paramount, and that flows right throughout the entire Cloudflare ecosystem and business model. Due process for us is key. We would not want to see this process being leveraged for overly broad requests by law enforcement or others. Our view to law enforcement is we're not there to make their lives any easier, but equally, you know, not to frustrate their legitimate efforts as well. So we do want to see due process there as well. We want to see transparency. Our view is that we should always be reaching out and contacting our end users if a request has been made on their data, absent any gag order, court order, etc., to that effect. But we'd like to see transparency put into that process. So, yeah, perhaps I'll leave that there. But it's been an interesting process for Cloudflare, to say the least.
Thank you very much, Caroline. And just to those of you who might not be aware, anyone can get involved in that process. For me, it's fascinating how this global standard is being developed by users, registries, registrars, and law enforcement has a say there as well, trying to identify the interests that are behind access to particular categories of data. So over to you, Gregory, for a review of that perspective. Thank you.
Thank you very much. Thank you very much for inviting me on this panel. So I'm Greg Mounier. I'm working for the European Cybercrime Centre, which is the cybercrime division of Europol, the European Police Agency. Why do you have a COP or a European Police Agency on this panel? Because we're one of the stakeholders. And that's something I would like to really clarify. Domain names, like IP addresses, are critical internet resources. This means that without that, the internet doesn't work. You can have protocols, you can have applications, the internet will still work, but for domains and IP addresses, if this is not governed in a sound way, then the internet will not work. If you are into the business of doing bad stuff on the internet, like if you are in the business of doing good stuff, you will need to have access to these critical resources. If you want to establish or to launch a new spamming campaign, you will need to use domain names. You will need to buy those domain names, or you will need to steal those domain names from somebody else. If you want to distribute counterfeited drugs or goods online, you will need to have domain names. If you want to establish a botnet, you will need to have domain names. If you want to do propaganda, I'm thinking about the investigations we carried out with the Belgian authorities last year on AMAC, which is the news agency of Daesh or ISIS, that they established over the years, and we investigating almost 500 domain names that had been registered directly or indirectly by supporters of ISIS without access to the Whois, direct access to Whois informations. We would not have been able to map out the infrastructure and take it down. So if you are a criminal, you need to have access to domains. If you are a prosecutor, an investigator working for a public safety agency, you need to have access to information in the Whois. So I think it is really important for you to understand. I think when it comes to law enforcement and judicial and prosecutor access to personal information in the Whois, which since May 2018 and the entry into force of the GDPR is now non-public information, so it has been redacted. The impact it has on investigations, I agree with Caroline, the sky hasn't fallen and the internet is still working, but I think that we're getting, and it's not I think, we're getting more and more examples from the various national investigations units that they have to delay their investigations. It's taking much more time to identify who might be behind specific badness on the internet, and sometimes, depending on the severity of the case, cases are just dropped because you don't have the technical means to identify who's behind. So of course a cop will never say, I stopped my investigations, but it will be parked indefinitely until the time where additional information comes in. So from a society perspective, giving privileged access to some entities who have a purpose and a legitimate interest to have access to that non-public information is actually critical for the sake of society, for the sake of business, for everyone. Now, if you look at CCTLDs, and Peter will talk about it, so these are the national country codes, so .uk, .be, etc., which are not regulated by ICANN, but they're often regulated by the member states, sovereign states who's dealing with it, but Peter again will explain better. If you take the example of Nominet, which is the registry for the .uk, they've anticipated, of course, the implementations of GDPR. They reviewed their policies, stakeholders management, they consulted everyone, and they reviewed their policy, and they came up with a very simple system whereby it is prescribed by law, but that law enforcement and the judiciary have special access to non-public information. So the Whois, basically they have free access to whatever they need. Of course, every request is logged to fight abuse, for transparency, for proportionality. And then when it comes to private partners, cybersecurity companies, IP right lawyers, they have less access to Whois information, but they do still have access if they have a legitimate interest. So what I'm saying is, it's not easy, but it is very possible to come up with a system whereby the different stakeholders have access to different degree of information in that information, depending on what the law prescribes. So I think that the challenge is not so much whether some stakeholders should have access to that information. The challenge is really the clash between the implementations of legislations, norms that are stemming up from regional or local entities based on a democratic system, in a rule of law based democratic system, and the implementation at global level of these regional laws. So if I want to be very clear, is for me this is a key test for the multi-stakeholders governance model, because you can legislate or regulate by consensus between experts on very technical issues. How should a domain name be distributed? What type of protocol should be established and adopted by the whole industry? IETF is doing a great job at this. But when it comes to core public security and public safety issues, I'm not sure that the multi-stakeholders governance model is fit for purpose. Or maybe it has to be refurbished, or it has to be works on the rules of who makes the decision. Because in the case of the Whois, we are in a situation where giving access to judiciary and law enforcement because they have a legitimate interest and there is a legal base in the GDPR, it's Article 6.1f and 6.1e, is possible. It's not even disputed. But because of opposing vested interests of different parts of the community, I think that the consensus is not possible. And there won't be an outcome which is preventing something that everyone agrees we need to give access to those who are mandated by law to fight crimes online. And so this is really, for me, the problem. Can we implement at global level principles that are coming up from regional entities? I don't want to go on too much about it, but I think it's, again, my point is there's no problem about giving access to specific entities who have a legitimate need to have access to that information, but how do you get to a compromise? And I'm not sure that the multi-stakeholders governance level is fit for purpose. Thank you.
That was wonderful, Gregory. Thank you. Every moderator loves a strong statement. That was a very strong statement. Thank you. I'm going to support the multi-stakeholder model, among other things, because it allows for direct interventions from the civil society, and civil society is up next. So the whole point of the multi-stakeholder model that ICANN is now testing when implementing the GDPR for what used to be the Whois database, quote unquote, is to have a direct input from the users, those also in civil society. I'm really excited about that statement, but I'm not going to go on. I'm just going to go over to Walter and let him do all the talking. Over to you, Walter.
Okay. I'm going to be annoying about terminology. First of all, we do not represent users. We represent what we think is the public interest, or more specifically, human rights, citizens' rights. So some people say that there are only 3 groups that have users, that those are the copyright industry, the tech industry, and drugs dealers. And I leave to do an exercise to the listener whether they have overlapping ethics frameworks or not. That said about users, I tend also to be, I'm sort of revealing my age. I tend always to giggle when I see the term of cyber. So I stick to the use information security or network security. Okay, yeah, I shall do so. Either way, I will briefly introduce EDRi and give some remarks on this process. EDRi is a, oh brilliant, that is so much for putting your presentation in a PDF. Can you help out with that bit? Either way, it's an umbrella of mostly European civil society groups active in the field of human rights in a digital context, and we have members in 19 countries in Europe. And our definition is the Europe of the Council of Europe. So more the Eurovision Song Festival Europe than the EU Europe, although in practice it's a lot more EU work than Council of Europe work. We've been founded in 2002 and have a Brussels office here, which I'm not part of. I happen to represent within the umbrella a Dutch member. Anyway, let's scroll a bit through this thing. Lovely, yeah, that works. What I want to go back to is the issue at hand here, or where we come from. You could argue that from, let's say, the mid-80s, this already was a bit of a problem, because in the Convention 108 implementations, you should have specific purposes for data processing. Even with a generous reading of all that, you could say that by the time the data protection, the European Data Protection Directive rolled around, so went to enforce about 1998, it was clearly an issue. So, like Caroline said, this is basically for the better part of a decade, I would say the better part of 2 decades, an issue. So I found it rather entertaining when people in the domain name ecosystem were panicking around May last year about this new GDPR thing, and I would not call this unintended consequences. I actually think there are clearly traces of the domain name discussion inside the GDPR. I will get back to that later on. I'm also a bit surprised about the variety of readings of the GDPR. I don't think there's any community anywhere in the European Union who has had so much specific guidance from the DPAs. There's a lot of complaining and moaning, and I'm part of the choir of moaning and whining people about the DPAs not being clear. The DPAs have been remarkably clear, with starting with letters in 2001. This is an issue. These are the things you have to redress. But yeah, to get back, what is the current status in the cycle? We've moved from denial and anger, at least for most of the stakeholders, into the bargaining phase, and that's how I see the initial report of the EDPDP. I would also say some stakeholders are still in full denial, but that's maybe for another panel. The proximate problem is basically the initial report is a step forward. It describes purposes. It attaches to them the basis for processing. So it's starting to match the requirements of Article 5 and 6 of GDPR. As far as I can see, there's a miserable failure to address the requirement to balance the legitimate interest of either the controller or third parties and data subject interests. And in terms of generic guidance, I should point to people who know it, to an opinion by the Article 29 Working Party of 2014, which provides a quite easy scheme to, well, easy, it's not necessarily easy, but a quite clear scheme on how to balance those interests. And I would say that quite a few of the purposes described in the initial report just fail that test. And I would say that some of those interests are just clearly illegitimate. Gregory meant the interest of law enforcement. I would say, yeah, that's probably a potential legitimate interest. But law enforcement will still need a mandate to get that information. It typically has. At the same time, there's this fundamental issue. Do you retain data for the purpose of maybe later law enforcement will ask for it? Or do you give law enforcement always access to information you have to data which you had for the let's say the execution of a contract? Civil society is very, very wary of ideas of retaining data just for law enforcement purposes if you're not law enforcement yourself. Interesting reading still the CEDAW judgment on the data retention directive, how problematic that easily becomes. And when it gets to IPR enforcement, you also enter into the problem of privatized law enforcement, and furthermore, IPR enforcement, I don't think that should take place at the level of the domain name registries. This is about like going after the road operator for the fact that on some street corners some legitimate goods are being traded. Gregory rightfully said this is a critical infrastructure. This is a vital part of the internet, and the perspective in our view should be this is in some ways, and Joanna will hate me for it, a public good or a public infrastructure, and it's being run by private entities, and that touches at the heart of the issue why we must have a multi-stakeholder problem, although that's the least bad option. We have this twilight zone of the internet being not necessarily a classical public-private sphere in the sense, and on top of that, it's a global infrastructure, and there are all sorts of concepts we take for granted in Europe, which we may not be able to take for granted elsewhere across the globe. So I would say for now the multi-stakeholder process is a panacea. It's not a panacea, it's more a surrogate for having a proper democracy and a proper rule of law at a global scale. So we do support multi-stakeholder models. At the same time, they're quite limited in terms of effectiveness, especially if they get hijacked. And I get the sense, judging by the outcomes of the current status of the initial report, this process got hijacked by especially the IPR enforcement people, which are not necessarily friends of civil society. And that is basically, I think, the ultimate problem ICANN is being forced to tackle, and it cannot tackle it. So in a way, this is doomed to failure, to fail. I would say, yes, Caroline is right that the next stage will be more controversial. I would say the current stage is all sufficiently controversial to be problematic. And yes, I shall shut up and pass on the microphone. Yeah, in conclusion, the initial report is a catalog of governance matters. I'm not sure ICANN should take that broad a role in governance matters. It might want to stick to just running the domain name system. That's about it for now.
Thank you very much, Walter. But just to emphasize, this panel is not so much, it's not about the report. It's not so much about the process that is currently going on, as it is supposed to be an example of how various, how diverse the interests within ICANN are. So we try to get here different perspectives represented rather than give you a review of the initial report, especially since it's quite lengthy. And I would dare guess there aren't many in the room who've actually read it. So I appreciate the perspective. I think Walter did a wonderful job in trying to emphasize where the controversies lie. So we've heard a little bit about the registries, about the interests of law enforcement, civil society, but there's one more piece to this puzzle, and that would be national regulation. On one hand, we'll have Cristina giving us the side of the Commission. But before we get there, there's this interesting section of CCTLDs, so country code top-level domains. On one hand, representing in some way countries, but on the other hand, outside national regulation. How is that, Peter? How does that really work? So I'm handing over to Peter. Give us yet another perspective.
Thank you so much, Joanna. Good morning, everyone. My name is Peter. I'm the General Manager of CENTR. And so we represent the country codes. And it's the first of the 3 points I want to make this morning. CCTLDs and GTLDs are worlds apart. So country codes, they manage and are responsible for country codes like BE or FR or UK. They take their policy, they write their policy themselves. They're not depending on ICANN. And they write their policies to the specifications, requirements, and interests of the local internet community, and obviously taking into account local laws. So that means two things. They're different, quite different from GTLDs, but they are also very different amongst each other. If you take a look at a country code like .dk for Denmark, they have a completely different take on privacy than you would see in some other countries, for instance in Spain or France. So that's a very important point to underline. CCTLDs and GTLDs worlds apart. EPDP will not affect CCTLDs. I'm not saying that some of the conclusions there or findings or new views would not be able to be implemented in CCTLD space if they're good, but as such it has no direct impact. Secondly, it's very important to understand, I think, that there is a big difference between data that is available and data that is publicly available. So if you look, and that already borders to the third point I want to make, but if you look at the trend and evolutions in Europe over the last decade or two, you'll see a trend towards data minimization within the CCTLD space. You'll see data minimization when it comes to publicly available information. Country code like .be for Belgium or .eu for the European Union, which is indeed a country code, have restricted or minimized the amount of information available in Whois since the beginning of the 2000s. For .be, I think the only thing that remains is still a contact form. For .eu, there is still an email address that obviously the registrant can choose, but there is no details anymore on phone and address, etc. So there is definitely that trend. Does that restrict our cooperation with those with legitimate interests? No. As Greg already explained, giving the example of Nominet, it is possible to come up with a solution where that information that is still available but is with restricted access can be shared while still preserving the rights of the individual. There is one thing I don't agree with Gregory, and for the sake of some discussion here on this panel, I don't think it's a multi-stakeholder issue. I think the problem is that the level of complexity in an ICANN environment is multifold because of the different jurisdictions that it's working with. If you look at Nominet, they can deal with the UK Data Protection Commissioner, they can talk to local law enforcement. They only have one set of legacy software to deal with. It is very complex to think or to think of a concept of an leveled access mechanism that you would then implement into these dozens and dozens of historically grown and developed pieces of very complex software that are running CCTLDs. Yes, some of them have the same basis, for instance, bind, but from then on they've grown with different extensions, implementing EPP, which is a communication channel with registrars in slightly different ways. So it's very difficult to come up with one solution that fits all. But on a local level, I think CCTLDs are succeeding in doing that, and still having those good and open discussions with their local internet community, including all its stakeholders, such as law enforcement, but also intellectual property rights and privacy advocates. So our world is slightly different. I think it's less complex, but it shows that there are solutions that might be helpful on a global scale. Thank you.
Thank you, wonderful. I'm looking forward to the questions. I'm hoping that we will try to identify the specific policies, whether there are ones that combine all the CCTLDs or whether they're different, but we'll leave that for the section, for the questions, for the section with the questions. Now off to Cristina. How satisfied are you with the process, looking at it from the Commission's side?
Oops. We have a short cable. Okay, thanks. Thank you very much. Thank you for inviting me here to present some of the perspectives from the European Commission. First of all, I would like to start by explaining that the European Commission, as well as all European member states, have been traditionally strong supporters of the multi-stakeholder model, and also of the multi-stakeholder model in particular embodied by ICANN. And we have been supporters and active participants, in particular through the so-called Governmental Advisory Committee, which is part of ICANN community. And in that body, basically, we address public policy concerns that are related to the domain name system. In that sense, the role of the Commission has been really to coordinate and shape the European Union position on matters with direct relevance for European Union interests, like, for instance, protection of geographic names, multilingualism, competition, security and law enforcement aspects, and most recently also data protection is now becoming really at the forefront on the agenda. And on this particular issue on Whois, all European member states have already recognized also that the data which is in the system is really important for many public interest purposes. At the same time, we should also stress that not all data is personal data in this system, and you have also a lot of technical information which is also useful. In that respect, we have acknowledged ICANN's central role and responsibility in ensuring that we have a stable and secure DNS system, and we understand that the Whois is part of the equation. If we had to draw some lessons, is still difficult at this moment, I would say, because we are still halfway in the discussion. So we have a temporary policy in place, which is not ideal because we don't have a full model in place. So we have different processes which are working to arrive at a system which is predictable and stable, which is what all stakeholders need. But at this very moment, we are in a situation which is less than ideal, and we understand the concerns, for instance, coming from law enforcement, for cybersecurity, but also from the individual user who is not fully aware of what the situation is and how is actually the data used and how can it be accessed or corrected for that matter. So if I would like to draw some lessons, I would like to stress 3 main points. We have to, I think also it emerged clearly from the initial introduction from Elena that we know that the internet was born in a different, with a different spirit. So, but in the meantime, it has changed. So initially, it was the space of total freedom, of trust and cooperation. And the DNS, which was built on that, at that moment as a critical infrastructure, basically remained the same, while the internet and what was running on top of it radically changed, and changed also our societies and our economies. But the DNS basically remained the same infrastructure with some upgrades, we could say, like for instance the DNSSEC. But the key is that security and privacy were not really the primary concerns of those who built this critical infrastructure. And Whois is just an example of that. It was created in a different time when the ecosystem was completely different. And it was created for a specific purpose. In the meantime, things have evolved, have changed. And now we see that the security and the privacy aspects were not really addressed. The second point is that, in my view, the GDPR has indeed been an incentive to finally put pressure on the community and address the privacy concerns that were very clearly highlighted by many players. So the GDPR is sort of forcing the community to bring a system like Whois in order. So it's really essentially an exercise of sound data management. So to define how the data is used, why it is collected, by whom, for which purposes. So these are basic, essential questions that need to finally be clarified. And in the end, I still believe that this will help having a better Whois system with more accurate data. So being even more useful in that sense, because I think it's in everybody's interest to have a system which works properly and also has some safeguards embedded in it. So. And when we discuss about the broader issue of different laws coming from different areas of the world and the impact they can have on the critical infrastructure, I would say that actually the GDPR brought more uniformity in the way these rules should work. So rather than fragmenting, we are going towards the opposite direction, I would say. So we have much more uniformity in the way the rules are defined. And we also see a strong trend in the rest of the world, actually, to converge towards common core principles of data protection. And as we know, also in many of the sessions that we had in this conference, it was recalled that, at least those which I attended, I heard many times that many countries in the world from all continents are working on developing data protection rules that are really converging towards these principles. And this is actually also good for companies, for trade, for facilitating the flow of data. So this is more on the general level. Going back to the multi-stakeholder model, and this is my third remark. I think that the multi-stakeholder model really works when the different stakeholders are really not entrenched in their own positions and only focusing on their own specific interest, but when cooperatively they look for common and workable solutions. Unfortunately, we see that often is the case that it is difficult to go beyond the specific stakeholders' interest, and I think it's normal in a way. But as Greg also was saying before, probably this is a test case for the multi-stakeholder model. Although in principle, I believe that it should be an easy case, because I believe that in the future we will have even more complicated situations where we will have to address different regulation concerning much more controversial issues like cybersecurity. Here, on data protection issues, it should be much more easy and workable to arrive at a shared solution. In conclusion, I think it's also a matter of trying to build bridges and communicate well among the different stakeholders. When we participated in these different efforts and work processes in ICANN, we see a lot of misunderstanding, a lot of misinterpretations of what the GDPR is or not is. And at the same time, I hear often that policymakers are not fully aware of the impact that the laws can have on the technical infrastructure, on the core essence of the internet. I think both sides are right, and that's why it's so important to make sure that there is this common understanding. And sometimes, you know, I really had the feeling that we had a sort of clash of civilizations, in the sense that we had the ICANN community with its own language and acronyms and so on, coming together or trying to get to grips with the GDPR, which is with its own complexities and acronyms and completely different language. So in the end, if I could conclude on a positive note, I would like to say that it's important to revive, in a way, the initial spirit of collaboration that made possible that the internet really flourished and became the essential tool that is part of our everyday lives. Thank you.
Thank you very much. Thank you, Cristina. I think this is exactly the essence of the issue. The reason why we decided to have the panel here at the Computers and Data and Privacy Conference is because this example here shows you exactly where privacy meets the computers and the community behind it. As our panelists have indicated, there are very specific technical communities where the multi-stakeholder model might be easier to achieve and might be easier to bring results. Whereas on the other hand, this is the ultimate exercise in GDPR and computers. So we have this global network, this universal standard that's coming from Europe, and the question how to implement it. Our idea behind inviting you here today was to show you the different interests represented in that dialogue, that very vibrant and emotional dialogue that's going on within ICANN, where ICANN is the platform for exchanging all those views. I'm happy to move on now to the section for questions. Are there any questions from the audience? Yes, wonderful. We have a gentleman here who's going to help us out with the mic. Please go right ahead.
Thank you. Good morning. My name is Corrie Ebbers. I'm an independent privacy lawyer from the Netherlands. And I have a fundamental question. In this case, the Whois register, who is the controller?
Who wants to answer that one?
My answer would be initially, since it is a distributed set of databases, the registrar who is basically controlling the domain name in question. The registrar, yes. Or in ICANN parlance, the contracting party. If I'm saying that correct? Yeah. For the rest, I don't exactly. Okay. Okay, and there's also disagreement on my side on my assessment that should be the controller. So I think if I may.
Yes. I think you can have more than one answer. If
I don't
anyone
really
else is
disagree. No, I'm not a privacy lawyer, and that was a very good question. And it's part of the whole discussion. So we have, yes, the data controller, of course, is the registry or registrar, and then you have ICANN, who dictates through a contract to the registry and registrar the collection, or anyway the processing of data, which also makes ICANN a data controller. Yes, I'm open to it.
Yeah, I mean, that has been at the core of the debate. As registrars, we would believe that ICANN certainly has a controller, joint controller function in many things. I think, you know, the complexity of the data processing activities within the ICANN model have been, you know, that is something that has taken up a lot of the debate. So, you know, we have the data that's flowing between registrars and registries, the data escrow activities that we have, the data is flowing between us and ICANN. So it's immensely complex, but this has taken up a lot of mind space for the EPDP process.
And to add to that, I should have been more nuanced. From a civil society perspective, I don't think ICANN should have any business in being a controller. We would advocate a model where the registrar is the sole controller for the domain names it is administering, and ICANN should stay away from that. As in, dictating this flow of data is against the spirit of data protection legislation. So indeed, we're at the heart of the controversy here.
But we are under contract with ICANN, who dictates how we need to handle the data. So, yeah, you see how complex this is.
We have one more answer.
And what is in the contract by ICANN is made up by the community, which makes the policy, and then it becomes a contract.
And we have sponsors of the CCTLDs.
Yes, so for the CCTLDs, the answer is, as always, slightly more complex. I would say, and I can come back to you with a bit more specifics, so let's get in touch afterwards. But in general, I think the majority of the CCTLDs consider themselves and have a contractual relationship with registrars from a controller perspective to a processor's perspective. However, it is complex on a different level too, so not just the diversity between CCTLDs, but if you see on the trajectory, the customer's journey of a registrant, it not always starts with a CCTLD registration. So he could be a client for a hosting service with a registrar. And then in addition, he is starting to add, in addition to his GTLD name, for instance, he's starting to add a couple of CCTLD names. So the original contractual relationship is with the registrar. Obviously, from a commercial perspective, the registrar wants to keep it like that and is always very careful to hand over control of his or her customer to the registry. But so in general, there's a controller and processor relationship. If I may add just one kind of quiz question to give it some perspective. Anybody has any idea what the share is of CCTLDs and GTLDs in the world? It is changing, but not dramatically. The CCTLD share is actually getting larger despite the introduction of new GTLDs. At the moment, it's about 40% of CCTLDs versus 60% of GTLDs. But mind you that of that 60%, more than 80% of that 60% is one single GTLD, that's .com. So just to give it some perspective. Thanks.
Thank you very much. Do we have any other questions? There's one. Thank you, sir.
Thank you. My name is Simon Ania. Aside from being a DPO, I'm also a member of the board of trustees of the Dutch registry.nl. And actually I have a question which relates to fundamental rights, because GDPR is not a privacy law, it is a data law which supports various fundamental rights. So what I'm a bit surprised about is that while there is a fundamental right to property, to security of person and to privacy, we do not seem to be able to reconcile these, which is exactly what GDPR is also intended to do. And I'm a bit surprised by civil society not taking that view. So Walter, please, why are you not also in support of security of person and actually advocating what law enforcement is advocating, but helping to condition it as part of the overall? So this is my proposal to salvage the multi-stakeholder model, because maybe the nation state isn't fit for purpose.
Oh, let's not get there. If I may, the typical role of civil society is not to be civil at all, to point at elephants in the room. And in this, what you're pointing at, that elephant is already quite clearly addressed in recital 49, when I already mentioned this specific legitimate interest of network operators and the wider community to have a wider legitimate interest to process personal data for those purposes. And I'm pointing at that one because I think most of civil society is quite happy with specifically mentioning that case, and also to point out, hi IPR people, your counterfeit problem, or so-called counterfeit problem, because that's way overrated anyway, you're not mentioned there. And stay with your sticky fingers out of an issue you should address via different means. And that's why I was quite happy with Gregory's contribution, because if for the most part, those are valid reasons. There are other issues there, and I think, for example, part of the problem of law enforcement is the shift of their own complete incompetence to talk to each other towards other actors, like we see in e-evidence and also in this process. I mean, part of the law enforcement problem should be solved within law enforcement. I would like to see a decent mechanism for any law enforcement agency to pass on, either via Interpol or Europol, for example, to pass on requests. Because the need to replicate the Whois database further than just the initial registrar is not necessarily there. Why are we doing this? At least for the law enforcement purposes, because law enforcement cannot properly talk to each other across the various boundaries of the nation states. So maybe getting back to your initial point, which you may be a good one, but I think that's too large an issue to discuss at the CPDP panel.
Thank you, Walter. We are almost out of time. I'm going to let Gregory respond to that as well, and then if our panelists have famous last words to share, I'm going to give them opportunity. We're down to last 2 minutes. Gregory, over to you.
Thanks very much for your comment. I think it's very topical, and I completely subscribe to this. At national level, for the .nl, for the .uk, for many other CCTLDs, the different stakeholders have managed to come to a consensus and draft clear GDPR and data protection privacy respectful system, so that everyone who has a legitimate access needs can have access to that information, and we don't manage to do it at global level. I understand that the degree of complexity is much bigger at global level. However, I think it calls for maybe a fine-tuning of the rules of how decisions are being made within the ICANN environment, and because maybe my statement was a bit strong, I do support the multi-stakeholders governance model. I think it's the worst form of government except for all the others, probably. Yet, I think this is a case where we need to fine-tune it, because, as Cristina was saying, we have other public policy questions coming up in the next decades, which will be much more difficult to address. And I think this is an opportunity maybe to make the decision-making process within the multi-stakeholders governance model more efficient, because you can't have a situation where private interest from different stakeholders is hijacking the ability to come up to a consensus. And this is what we see in the PDP. You have the business constituency, you have the registrars that are opposing the NCSG, so the civil liberty advocate, and there's no consensus possible because nobody's going to give ground on this. And I think that's a problem.
Works? Yes. Thank you. So, yes, the issue here is to comply, of course, with GDPR, and at the same time, find a system that will allow access for legitimate usages to mitigate all these issues that the Whois was there for, to the extent that is possible. And GDPR does not forbid access. It doesn't say that the Whois has to go dark. At the same time, the GDPR is a law that allows different solutions on purpose to adopt to your particular situation. And if I'm oversimplifying, please correct me with that. Caroline I alluded to the thing to this before. The issue here is finding a global solution. And there are 2,500 contracted parties which have their own interpretation of the GDPR, And your very good question here, who is the data controller, is part of it. So this is part of why the guidance from the DPAs is critical in this process. And yes, we're happy to say that, or proud to say that we have received guidance, a lot of guidance, if you compare it with other sectors from the DPAs, which is very, very helpful. And we hope this will continue, it's necessary. Although we know Whois is a very small part of the DPA's huge workload right now. A comment back to you, Walter. Sorry for that. You said that the critical infrastructure, the DNS is the critical infrastructure are run by private entities. No, that's not accurate at all. Yes, the Internet Unique Identifiers are public good. It's not my words. There are norms by the Global Commission for Security and Stability that recognize it as a public good. There is wording now in the new CYBERSECURITY Act that refers to the DNS as a public good. Under the DNS directive, many member states of the EU have declared the DNS an essential service, and it's not being run by private entities. Maybe one separate domain name, yes, that is they sell the domain names, but overall, the DNS, the allocation of the IP addresses, this is done by many organizations. I need a multi-stakeholder. That's why we have a multi-stakeholder behind it, because the global community is responsible for running the internet, not one entity or a private entity. I agree with Peter. I do not see this. This is not a problem of the multi-stakeholder model as such, but I also see the point of Greg that it is a test to the multi-stakeholder model. When he said that, I think Cristina put it in the best possible way when she summarized that it is about working in a cooperative manner. That's the whole spirit of it. And at the end of the day, it's our shared responsibility. All of us are part of the multi-stakeholder model, us who are sitting on the panel, every one of you who is part of the multi-stakeholder community. It's up to us to make it work.
Thank you, that is so wonderful, famous last words. Any other famous last words from our panelists? Yeah, all right.
Thank you. Just very shortly, just to say that, okay, I think that there is room for improvement in the way the multi-stakeholder model works. The whole process has been a bit chaotic and confusing at best. So I think it's really important also for ICANN to make an effort to establish clear timelines, clear understanding of where we are going, and also, as I was saying, a lesson for the future, because I really believe that this whole issue has caught ICANN a little by surprise. And I think that in this respect also the role of the European data protection authorities has been really important, because they have kept an open channel to convey important messages, and I think that this is really important also as we move forward.
And just one final point for me. I think Cristina alluded to a very good point. This was really demonstrative in the fact that the internet infrastructure industry was not involved in this debate from the very outset. And I think we could draw lessons from this, and I think ICANN has made good steps to that effect. So increasingly the DNS industry is being referenced in pieces of EU legislation. So we see the terrorism regulation, e-evidence, consumer rights, DNS, registries, registrars are being called out. And it's incumbent on us, the industry, to get more involved in these debates from the outset, to make sure that there really is an understanding in, okay, if we're going to legislate in this way, this is the impact on the internet, and this is kind of the outcome that we're going to face. So I think it's a learning lesson for all of us, this debate.
Thank you. Walter? Yeah?
Yeah, I should also emphasize there's more at stake than, let's say, law enforcement access and IPR enforcement access versus data protection interests. My personal interest in this topic is mostly because of the chilling effects on freedom of expression, religious freedom, in some sense, in some contexts, some domain, or let's say some internet infrastructure also essential for the freedom of association. and these interests are underemphasized, and in a way I was deeply disappointed by the letter from the Commission towards ICANN in that respect, which was kind of wishy-washy, and the Commission, as a guardian of all our fundamental rights, could have paid more attention to those as well.
Thank you. Thank you, everyone. Please join me in giving a hand to our panelists. And sincere thanks to our audience for joining us this early on a Friday morning. Thank you very much, and have a good day today at the conference.